All right, good afternoon. My name is Patrick DeRay, Chief of the Bureau of Automotive Repair, and I want to welcome everyone to the regulatory workshop, public workshop, dealing with, I don't even have my agenda for this. It didn't make my file here. It's dealing with disclosure requirements relating to tear down estimates and tear down repairs. And we have a presentation that we will be giving shortly. I'm sorry, we are just now getting everyone back into the room. We had a bar advisory group meeting that ran a little long, and everybody just went out to get a quick bite, and they are, oh, thank you. I got the presentation now. I didn't have it in my folder. That's all right. 8. I'm just stalling to get everyone back here into the room. Anyway, we are now going to hold today's workshop on tear down disclosure requirements for automotive repair dealers. This is a topic that has come up, and the need for these regulations, at least in the Bureau's eyes, were brought out due to some revelations in our handling of some consumer complaints and some thoughts about how to improve the communication between automotive repair dealers and consumers and transactions where tear down estimates are performed. This can happen in a mechanical repair scenario, but we find this more and more common, obviously, with and some of the communication issues that we've been experiencing and having to tackle through our consumer complaint mediation efforts in the collision repair, auto body repair environment. So while that has application for the entire industry, we certainly see its value most notably in that collision repair scenario. Let's proceed with a presentation, a brief presentation. All of the information about this workshop, including the draft regulation text, is posted and has been posted on our website as of 10 days ago. And that is the current version of the regulatory text. Purpose of the workshop is always for us to vet out the text with our stakeholders and find out if there's some major opposition that we could expect if we were to move forward with these regulations. Or some fine tuning that could be made and some concerns that we would like to address on the front end before filing those regulations with the Office of Administrative Law, at which point there would be another opportunity for a public comment, but this is a better way in our mind to get those comments out on the front end and make those adjustments on the front end as opposed to midstream in the middle of the process where it's much more difficult and challenging to do so. It also gives us the opportunity to, as we have in some instances, pull back a regulatory proposal and decide not to move forward with it. I don't know if that's the case in this situation. We've heard already that there might be some comments about the proposal, and we're all ears, and that's why we're having the workshop or hosting the workshop today. So without further ado, I want to introduce Patrick Lutfi from the Bureau's Enforcement Operations Branch, who will give us the presentation that we've put forth. I think it's a pretty brief presentation. And then at that point, after he's done, we'll open it up for comment and questions regarding the proposal. Welcome, Patrick.
All right, thank you. Good afternoon, everyone. I was hoping for a longer lunch so that everyone could get tired and reduce the number of questions, especially from the rumblings I'm already hearing, but here we go.
Power bar here.
All right, so this is a very brief presentation. It's just a couple slides long. So I'll get through this pretty quick. And then the proposed regulation text is a handout here, and it's also posted online. So we'll go to the first slide, please. So the background here, obviously, we get to, there we go. Background to this proposed regulatory language, we get to this various reasons, whether it's through legislation or through observations internally or within this arena as well. So through various bar complaint mediation efforts and observations, we've seen that there's still some confusion, or that there is a trend of confusion with consumers on insurer copays, even after signing teardown estimates, where there's a disclosure, and sometimes these disclosures tend to be vague in nature. So we've noticed that there's some confusion left with the way some of this is being documented. Vague descriptions of work to be performed on teardown estimates is another common thing that we've seen through some of the complaint mediation process. We've also had some meetings, various meetings, even most recently had one with the California Auto Body Association. We've had some in the past where some of this has been discussed, or these issues have been reviewed and discussed. And ultimately, our goal with this is to amend existing California Code of Regulations sections, to add some clarifying language on these topics, to existing definitions, provide some additional definitions in terms that are relating to disclosure requirements, and to clarify estimate work order requirements relating to the vehicle teardown estimates, including those involving an insurance claim or third-party payer. Next slide, please. So the two sections that are being looked at in this proposed regulation is 3352 and 3353. This next slide here is kind of a broad overview of the changes to 3352, which is the definitions. Specific job is being defined pursuant to, or Business Profession Code 949 requires that an ARD provide an estimate that includes an estimated price for labor and parts for a specific job. And teardown estimates would require that a specific portion or area or specific component to be disassembled. Teardown definition is updated to be consistent with the specific job definition. There's addition of pre-loss condition, also third-party payers such as aftermarket warranty providers, insurers, other entities contracting with the consumer to pay for a portion of the repairs or the maintenance being performed. Next slide, please. The second section, 3353, estimate work order requirements, specific to teardown estimate. The requirements are being changed to be consistent with the changes to 3352. There's an addition of a new requirement for an automotive repair dealer to disclose the number of days after presentation of an itemized estimate, or after the completion of a teardown and providing that estimate after teardown, that the customer has to authorize the repair or remove the vehicle. So it's giving a time frame that is no less than 6 business days, and this is consistent with CDI regulations on the number of days that an insurer representative has to inspect the vehicle at the ARD, or upon request by an ARD. The itemized estimate for repairs after teardown, we've added in a requirement for the ARD to include the amount that the insurer or any other third-party payer is going to pay on that claim. So basically defining what the third-party payer is paying versus what the consumer is going to be responsible for financially at the end of that transaction, as well as some minor grammatical changes. Next slide, please. That was it. Told you it was very brief and quick.
It's one of our shorter regulatory proposals, and but I don't know that it lacks in terms of comments that we might receive on this workshop. So I will open it up for that. But very quickly, I forgot to say at the outset that we are having this meeting both in person and virtually, remotely through the WebEx platform. So our public attendees can participate just as easily as those who are in the room with us presently. And then we are also webcasting the meeting, the workshop, which means it's being recorded and will be available on our website in roughly another week or so. So if anyone wants to go back and revisit what was said, or miss the meeting and wants to find out what was said or covered in the meeting, they can do so. All right, let's open it up. Let's start with those who are sitting at the dais with me from the Bar Advisory Group, the holdovers from that meeting. Thank you for sticking around. Or anything you want to chime in as far as questions or comments relating to the proposal? I'll look mostly to the right here with Jack Maladanov, representing the California Auto Body Association.
Hi, Thank you very much, Patrick, for the presentation. So I know we've had discussions of sort of the 30,000-foot level, and now we've got some specific language. I do have comments that I want to go over. We did forward when when the language did come out, we forwarded it to members and we started getting some feedback. So let me sort of go over them and then we can have, open it up. But there's kind of like 4 areas maybe that I think that were sort of highlighted. The first area has to do with the actual definition of tear down, which would be in the text 3352 A2, but in terms of starting to define a specific job shall adequately describe a specific portion of an area of a vehicle or a specific vehicle component to be disassembled. So the concern has to do with the specific portion or area of the vehicle. The comments that I had received, and we've talked about this before, under current law, I know it's very broad. It doesn't sort of limit when you do a tear down in the collision repair industry primarily. So when you have damage, it's understood you're going to repair the damage that was done to in terms of the vehicle. The shop and the customer kind of understand that car was involved in collision. There's going to be a tear down of components there. The way this is drafted, the way I read it, is that you're asking, or this regulation would require the collision repair facility to be very specific as to the area of damage. So in other words, example, car was hit in the front right-hand side. The way I read this now, the shop would have to say that we're going to tear down the front right front fender or hood or something in the front of the right side of the vehicle. The concern is that it's so limiting that if the vehicle was involved in a sort of an accident where there's damage underneath, and the shop had written up the tear down just specifically on the front end, of the right front end, there's going to be a concern that they'd have to stop in midstream because they discovered damage because it's a unibody underneath the car, and they would have to then possibly have to revise a tear down estimate. Now, and they can go further. Maybe the car was hit, the way it was damaged in the collision. Maybe there was some damage in the rear end. The wheel was hit by a curb. The curb hit the wheel, and there was damage. And in that case, they would have to then revise the tear down again. So there could be 3 revisions to the tear down, which doesn't make, in my opinion, doesn't make any sense. I don't, because in fact, the regulations don't even address that issue. You don't do revisions to a tear down. It's only one tear down to disassemble a vehicle. So that was one comment or one area. I know we've talked about that. The second area was the definition of pre-loss condition. I'm not a technician, but I did receive comments from some members who said, no, we're never going to repair it to pre-loss condition. We repair it to factory manufacturer specifications. And I was given an example, and I'll just read it right here because it's tech. In this case, some models of the BMWs require the use of rivets in place of spot welds when replacing front rails and aprons, as well as many other locations. But this is the most obvious, as one side will have factory spot welds and the repair side will have rivets. BMW believes it is not possible to spot weld structural panels in the field adequately. This goes for steel as well as aluminum panels. These are readily visible and not hidden by other panels, as in the case for riveted quarter panels and rear body panels. And in this example, the car is not repaired to pre-loss condition, but to vehicle manufacturer specifications. So I guess there's a concern that when you're saying the car, pre-loss conditions versus vehicle manufacturer specifications, there could be some confusion, some inconsistency, because under current law, under 3365, the collision repair facility is supposed to repair the car to vehicle manufacturer specifications. So that was the second one. Let me just go to the third comment or feedback we received. And that has to do with the section at 3353 E, or let me see, C1E, but it deals with the 6 business days in terms of, let me see the section, I'll read it. The number of days after presentation of an itemized estimate after a tear down that the customer has to authorize the repair or remove the vehicle from the automotive repair dealer, which shall not be less than 6 business days. The way the members have read this is basically that after you present the estimate, the customer here will have 6 business days to make a determination. And again, when you're talking business days, that with holidays and weekends, that could be as much as 9 or 10 days. They're like, wait a minute here. We have flexibility under current law. We want the customer to make a decision pretty quickly here. We don't want to wait 10 days. And then there's a question about storage. Will they be able to charge storage? Why should we give them 10 days? Can't they make a decision very quickly? So there was a lot of concern about the 6 business days. That was the third issue. And finally, this is 3353D, estimates involving an insurance claim or other third-party payer. So the way it reads is, in an automotive repair transaction involving an insurance claim or other third-party payer, the itemized estimate, the estimate now shall include the amount the insurer or the third-party payer is paying on the claim. The feedback I got is that that's impossible. There's no way to determine when you present the estimate, that's why you provided an estimate, how much an insurance company is going to pay at that point. So there's no way they're going to be able to comply with that. And then the other concern was, frankly, that the shop may not be able to get that information. I mean, they have a contract with the customer. They're dealing with the customer. With a third-party insurance company, the shop does not have a contractual relationship with the insurance company. So the insurance company may not want to provide anything to the shop. I mean, they don't have a relationship. They may ask. The insurance company says, hey, you're not the insurer. We're not going to tell you anything. So anyway, those were concerns there. And that was the fourth kind of concern. So I sort of wanted to highlight some 4 areas that we received feedback and wanted to at least bring it to the attention and have some discussion with you to see if, we can sort of, come up with solutions and work through these issues. Thank you.
Thank you, Chad.
So I was going to say, well, first off, good comments on all the areas, and you threw a lot at me to have to comment on all of it at one time, but I think on a couple of them. So as far as the tear down, all regulations and statutes, they're somewhat vague in nature, because you can't paint anyone into a corner or a tight box that is so restrictive that there's no flexibility. There has to be some flexibility with all regulation. But at the same time, we expand with our regulations to provide some level of consistency or disclosure. It can't be so vague that in an instance where a consumer doesn't understand what's being done in their car. So tear down. I don't think the intention is that you have to be so specific to every component that's going to be taken apart on a car. And we've had these discussions. So, but to say that I'm just going to tear down the damaged area of a vehicle, if a vehicle is damaged all the way around the car, but only the front part of the car or the front corner of the car as a result of an accident, does a consumer now expect that repair facility to tear down the entirety of the vehicle and give them an estimate? Or is it specific to the area that the damage occurred or any relating damage as a result of that accident? So there are ways that you can still, I think, articulate the area in which you're going to tear down the vehicle that expands into the undercarriage or something that is a result of that damage, but still advise the consumer clearly enough that they understand and have a clear expectation of what you're doing. So again, I don't think the intention is to be so specific, but at the same time, not so vague that there's no understanding.
Let me just respond, if that's okay. I think that we need to work on the language, because the way the language reads now, it is very prescriptive. And I think this is the way it reads now, it's going to allow, like I said, you're going to get into this area where you're going to have to do revisions to a tear down, which has never been intended, right? I mean, right now, the shop, once they do a tear down, you get one bite at the apple, right? You're going to have to make sure you disassemble and give an estimate But the way this reads now could be very prescriptive. So I think we can kind of work on language. I mean, I think this is an area where I think it's just a matter of tweaking the language to find the right balance. But again, I do think there's going to have to be some leeway for the for the collision repair facility to, at least deal with the damaged area and not get too prescriptive. So anyway, I think we can work on that area.
No, and agreed. I was just giving a little bit of background to that, or a little expand on explaining the intent there. As far as pre-loss conditions, some of the others, I mean, I could obviously take that into advisement. I wasn't 100% involved in the drafting of this proposed text, but even just to touch a little bit on the part with third-party payer, this isn't something that's new. It's not new to the automotive industry. It's not new to various industries. Insurance third-party pay is a common practice across multiple fields. It's in medical, it's with our homes, it's with cars. I mean, it's something that everyone is accustomed to using, and it works elsewhere. And I know anytime I've used my insurance for anything, there's always a clear understanding of what my out-of-pocket expense is going to be prior to engaging in that transaction. And that's the intention here too, is that a consumer has to know that if the teardown estimate, and I know this has come up in conversation here many times where insurance companies are trying to drive down some of these prices, they're not willing to pay for certain things, and to put a disclosure in an estimate that you may not, or that the insurance company may not pay for the repairs as we've estimated it, and you're going to be responsible for it at the end of the day. I think with the common practice and use of insurance across multiple industries, there's still a reasonable expectation to the consumer that I pay for my insurance, I'm bringing it to you as an auto body repair facility, and that I have an insurance that I pay for that's going to pay for these repairs. Yes, the contract is with the consumer, but if my out-of-pocket is $1,000 deductible, $500 deductible, it would be reasonable to expect that when I pick up the car, that's what I'm paying for. And to have this unknown question mark of what you may be on the hook for because the insurance company didn't approve it because they're not willing to pay for the level of repairs that the shop is performing without that being communicated to the consumer is problematic. So that's the intention there too. Whether or not there has to be revisions to the language, there has to be something so that a consumer has a proper understanding of what their financial responsibility is at the conclusion of that transaction.
And I appreciate that, but a lot of that has to do with the, consumer has an obligation here to communicate with their, with the insured, right? I mean, they're paying these policies. I mean, they should be getting answers from the insurance company. I mean, the shop does not have a contractual relationship with the insurance company. So this is kind of a gray area, and because you have jurisdiction over the automotive repair arena, but not necessarily the insurance companies. And so sometimes shops are caught in the middle, but once you start putting this in writing and kind of realizing, wait a minute here, it puts the burden now on the auto repair shop to be sort of working, or at least representing the customer with the insurance company, getting information. I think we're going in a gray area and maybe a dangerous area. And I wanted to make sure we had more discussion on this, because this is not easy. I mean, it's easy to talk about a 30,000-foot level, and we may agree, but once you start putting in writing, you're like, oh boy, okay, this now changes the dynamics, and we want to make sure whatever we do, we get it right. It's fair. It's fair to the shop. It's fair to the consumer. And so, like I said, I just wanted to raise those comments with you, and you'll hear from others, I'm sure. But I mean, I think we have some work to do in this area.
Thank you.
Thank
Fair
you.
enough. Yep, thank you. Additional comments? I'll go here first, and I'll get to you, Pete. Go on.
Just real quick on 3353, number 1B, I think one of the concerns we always have is when we're involved in a tear down and trying to determine what exactly is going to get torn apart that we're going to end up having to replace to put it back together to get the customer to be able to leave. And just even on the automotive repair side, that's always been an issue. And so maybe having something a little more descript in B that kind of sets some parameters for that. Because sometimes you don't know until you're pulling a panel down and all of a sudden stuff is falling apart behind it that you had no knowledge of until you removed it. Now all of a sudden you're responsible for putting the vehicle back together to at least enable the customer to take it somewhere else. And so that is a concern.
Okay, thank you. Bryce.
Hi, Patrick, I'm hoping you could help me for a minute, okay? I'm gonna freely admit, this is not my area of expertise, but I do have some thoughts, okay? The first thing is as I was looking at this, I'm trying to make I'm trying to differentiate between what happens in auto body and what just happens normally in an automotive repair shop. If a guy brings his car in and it won't start, and he goes, "Hey, my car won't start," then we're going to go through some diagnostic routine to try to figure out why it won't start. If the guy says, "Hey, my piston came out of my engine here, what would it take to redo, get me a new engine?" We would go through some diagnostic to try to figure out what's damaged and what it's going to take to get him going again. I'm going to steal a word from Gene Lopez over there. You guys are talking about tear downs. He used a word that I agree with, and it's disassembly. Normally in an auto shop, you're going to say, we're going to disassemble this and inspect it and figure out what our recommendations are to get you going again. If all the things we're talking about had nothing to do with auto body, and a guy came in and the front end of his car was, crunched in, we'd go, okay, we're going to have to do an inspection on this vehicle and see what pieces are damaged, whether it's on top or underneath, do an inspection, and then come back and tell you what we think that estimate's going to be. In our lingo, that is our customer, not the insurance company isn't our customer. That guy's our customer. And if we come back with what the estimate is for the inspection and what the estimates are for the repair, the fact that it's auto body or it's an engine, I don't know why there's that big of a difference. But at the point where it's going to cost, $8,600 to get this thing fixed back up, that's the amount we're now presenting to the customer. And the customer can go have a discussion with their insurance company, and some credits can get applied to that bill by the insurance company paying some, and then the customer paying some of whatever the differential is going to be. But the shop was able to diagnose what was wrong, doing normal shop routines, do an estimate using normal shop routines, and an estimate and what the costs are going to be. And then these two guys get to figure out who's going to pay what. Shop does the work and we're done. I'm having trouble figuring out why it's different than that in this environment.
Uh, uh, Because insurance is not typically used for mechanical repairs, although it can be when there's vandalism, you could have something thrown in a gas tank where it becomes an insurance claim. But the most commonly used one is probably when we're talking warranty companies.
Mhm.
So there are still instances in general auto repair that happens very frequently in which a car comes in, there's a warranty issue. The consumer goes in, it's diagnosed. It is determined prior to those repairs being performed whether or not it's covered by the warranty or is there a cost to the consumer. And that's fully disclosed prior to the repairs take place. That's exactly the same as insurance pay. And that's part of what we're doing with third-party payers. It could be a warranty issue. So it does happen in other instances. It's not, we're going to fix your car and then we'll see whether or not it's covered under warranty. That's usually done on the front end. And that's the same concept here, is that it's not the 5 o'clock special for various reasons. It's this one being, what is my financial responsibility when I pick up this car? Is the warranty going to cover it? Is the insurance going to cover it? What is my out-of-pocket expense? So they can make an informed decision. Maybe they can't afford to fix it at that given point in time. Maybe they do have to shop around and determine whether someone else can do it at a more reasonable price for that individual, but they have to know what their cost out of pocket is at the end of it. So warranty happens a lot. And maybe that's a better way for you to kind of compare the two, or a comparison for yourself between auto body versus general repair that's more commonly seen.
Thank you. Thank you for your comment.
Dave Kusa.
Thank you, Pat. Pat. Surrounded by
He's-
Pat.
Patrick.
Patrick, sorry.
There you go.
Thank you, Patrick. Number of questions. So pre-loss condition, is this paperwork, is this to the extent of this regulation? Or is this just changes to the regulations? Because if I'm reading, if I read it closely enough, I didn't see pre-loss condition used in this regulation. So is it used in other regulations?
It's being defined and added here. So if it's not common knowledge, anything that's strucken out is a deletion. Anything that's
Right.
underlined is being
Okay.
added. It wasn't there previously. So this is an added definition that was not there before.
Got it. Okay. So, coming from the repairs, I'm a, repair shop owner. Would, for me, cars driving down the road, everything's perfectly normal, transmission breaks, car comes to me, and then the customer declines to make repairs after tear down and estimates are supplied to make the repairs, am I restoring it to when it came to my door? Or am I restoring it to before the transmission broke? What is the pre-loss condition from my point of view as a shop owner?
So I'd actually have to ask someone else on pre-loss. I've heard this terminology used before. Me personally, I think it's probably maybe more commonly used in the
That's what I'm saying, right? Because
collision-
obviously
within
this is
collision
applying
repair.
to ARD, regular, I mean, mechanical too, so.
So pre-loss would be pre-damage is the way I would read this and the way I would interpret it. If anyone wants to correct me,
No,
there you go.
bringing in the big guns,
Save me on this
bringing in
one.
the big guns.
Pre-loss condition is borrowed from the California Department of Insurance frequently mentions it in their regulations in preparing an estimate or having a policy cover to repair a vehicle to the pre-loss condition. I certainly accept the comments that have been made here, Jack, yours and others. And we're definitely going to take that under advisement to look at maybe using different wording. We just borrowed it from there because it was convenient. There are sections in this regulation that do, in the entire regulation section, the 3350 sections, that do mention provide an estimate to the consumer to repair the vehicle to pre-loss condition. And anywhere that term is used, we're going to look at maybe switching to manufacturer specifications, repair the vehicle to manufacturer spec, whatever. We'll have those discussions based upon the input we have. To the comment about the transmission, again, it would be, if they brought the vehicle to you, when you prepare an estimate to repair that transmission, it would be to repair the transmission to how it was working before the torque converter let go and sent metal through the entire
Well, so that's not
transmission.
what I'm really asking though.
Yeah.
So, car's driving down the road perfectly, torque converter fails, right?
Right,
Car gets towed to me.
right,
My tear down is take transmission out, look at all the parts of the transmission, provide you with an estimate to replace all needed components in
Right.
transmission. You say, no, thank you. I put transmission back together, put it back in the car, right?
right.
That
You
would
do
be-
not
that's my
have to
tear down
restore it.
estimate.
Your tear down estimate is to restore the vehicle to the operating condition before the
Okay,
transmission
so
failed.
when it got to
So
me,
your estimate that
Yeah.
you generate from that tear down
would be
is what
fixing
it's
the
going to
car.
cost to fix it right.
right.
And if they decline that estimate, you're under no obligation to return it to that condition.
Got it. Okay. Yeah. I'm not, my
Right.
point is, where is pre-loss, right?
Pre-
So.
Pre-loss is before the part,
Yeah,
before the
before
thing
it
broke.
shows up at my, the condition of the vehicle that it shows up at my front door is the condition I would want to restore it to.
That's exactly
tear down.
what the tear
Yeah.
down laws requires you to return it to that
Got it.
condition.
Okay. So, and I think where maybe to Bud's question, where tear down is kind of unique to, transmission type stuff or auto collision, auto body,
Mhm.
right? Those of us that don't necessarily, I take out the old transmission, put in the new transmission.
Mhm.
So we get, and I do it in my shop, but a lot of shops so as an example, right, something's wrong. We need to remove your valve cover to determine what's wrong.
Right.
So I'm going to quote you an hour of time to take off the valve cover,
Right.
right? Okay. Oops. It needs $10,000 worth of work on this cylinder head. I don't want to do that, Dave. I'll just come get my car. Okay, well, I need $200 to put your car back together, right? Then that's the wrong way to do it. I know that,
Exactly, yes.
right? But that happens a lot, right?
Right.
And because we don't think that way, it's like, why wouldn't you fix your car, right? So obviously, it's take the valve cover off, put the valve cover on with any needed gaskets or seals would be the tear down estimate, right?
And tear down is really a fancy term used in the collision industry to describe a diagnosis.
Right,
It-
Yeah,
it's
exactly,
How the
yeah.
collision industry performs a diagnosis.
right.
And to Bud's question and to your comment, what we're really saying is the way the statute and then the regulations adopted pursuant to the statute on tear down is that a diagnosis should really, to remove the valve cover, that diagnostic charge that you quote up front before you pull the valve cover should contemplate having to put the valve cover back
Right,
on.
because the customer
and-
can
and
always say
send the
no.
car out with them
If the
saying
car
no.
drove in, it's safe to assume it could drive out.
That's it.
Yeah.
That would be a great world if we could
Yeah,
get there.
exactly. Yeah, yeah. And that's, I do that and I encourage all my friends and family to do that. But I guarantee you, there's a whole bunch of guys putting cars back together for free.
Right,
Because they learn that, they never learn the lesson.
right.
Okay, so that makes sense. In the
But Dave, how's that possible? I mean, when you do the disassembly and springs are flying out and all, things
Well,
are
well,
happening,
well,
how
I mean,
how do you put it back?
So a good example, but would be a differential, right? That, we need to take the cover off the differential to look inside the differential. So the estimate I'm going to give you is take the cover off, look inside, put the cover on with a new gasket, put new oil in it. Well, when 12 gears fall out,
Yes.
I clearly can't, right? And that's in regulation.
That's
here.
covered in the
Yeah,
tear
it
down
is, yeah.
regulations as well,
Yeah.
and maybe needs more ARDs need to apply that to their diagnostic process, is you must include a statement that says the act of tearing down, disassembling, diagnosing, whatever, may render the vehicle inoperable.
Yeah.
We may not be able to have you drive it out.
Right.
It's unfortunate, but when we pull the valve cover off or we would pop the diff cover, this car may not move anymore.
Right, exactly. Maybe the, yeah, right. And, bolts break, those kind of things.
Yes.
You can't anticipate
Yeah,
that, right?
and so,
yeah.
and all the regs, I say all the regs require, what the regs require, and it's all about disclosure, about, to my good morning story earlier, just proper information to the consumer so they can make an informed decision, like Patrick said.
And then on, thank you, on 353D, the estimate involving insurance claim or third party. So yeah, we deal with, some insurance, traditional insurance, but yeah, warranty companies all the time, right? So, and we do, as you described, Patrick, right? To note on the repair order, if there's additional cost to the customer, what the third-party insurance is paying, is that like just a note in my notes section? I mean, is there prescribed language of what that has to look like, similar to like, if a third party, if I'm authorizing a third-party person to fix my car, they have authority to authorize repairs, right? We have in Write It Right, we have a way of doing that. Is that important on this, or can I just, hey, right on there, insurance company paid $2,000?
So there's no provisions on exactly how that's to be documented at this point, other than the fact that it has to be disclosed to the consumer and just documented.
Okay.
It's not specific, like the sections you're talking about, or even with additional authorization, it's very specific as date, time, things like that. But advising them of their financial responsibility versus, so your out of pocket is your $1,000
Right.
deductible, or your out of pocket in addition to your $1,000 deductible is, or even giving options. I mean, I could think of a bunch of scenarios where insurance company is not willing to pay for this method of repair. This is what they're willing to pay for, whether it's a improved part, like you don't want the aftermarket part, you want to pay for a factory part. If the consumer is willing to pay the difference for a better repair, that's fine. But again, it has to be disclosed to the consumer. They have to know that that's not something that the insurance is covering. It's an additional out-of-pocket expense to
Okay.
them. So that it's just them understanding their portion of the
Yeah,
payment.
so simple language disclosure anywhere on there that everybody can understand, like regulation states.
Not a,
adequate.
you may be on the hook for additional
Right.
cost, but
Right.
not know what that additional cost is.
Exactly. Good. Okay. I appreciate that. Thank you.
Dave,
And
I
then
think you raise an excellent point, and maybe I think we will consider crafting specific language on how that should look.
It would help everybody. Yeah. Yeah.
Okay.
And then lastly, our number of days. This is a huge one for me. Most of the time it's a consumer pay. I don't want to give the consumer the option of saying, I'll get back to you in 6 business days, because this thing's sitting on my rack for 6 business days and I can't fix cars on that hoist for 6 business days. I get that it's already in, regulation with insurance side of it, which, again, now another question is that regulation on the insurance side apply to extended service contracts, which is essentially insurance, or is it traditional, collision repair insurance? Because I don't want to give those guys that option either, right? Because they're going to say, usually they're pretty good, but if we got a $7,000 or $14,000 transmission, like I have sitting in the shop today, that they're only paying $7,000 of, I don't want to give that guy 6 business days to come verify the complaint, right? He needs to be there the next day, or if not sooner, right? So I don't want to give him that option. Plus, I don't want a car torn down on my rack waiting for somebody to say, yes, please fix my car, or no, put my car back together for 6 business days. That's huge for us.
Okay. I think we were looking at the collision industry specifically there with the CDI regulations that say insurers have up to 6 business days to inspect a vehicle upon request. So, yeah, excellent point. We need to go back and look at maybe crafting that to address different scenarios. And really the intent of that there is to, Business and Professions Code 9884.8 says no additional charges can accrue without customer authorization.
Right.
So after your diagnosis, the way that statute reads is you can't start charging storage because that's an additional charge without authorization. And so if you tell them on the front end, that gives the ARD the flexibility to charge that storage if they haven't authorized it or removed the vehicle within a set number of days. And yes, we're obviously open to discussing the number of days and maybe working on that. But really, that's more to give the ARDs the flexibility to legitimately charge that storage by providing the notification up front.
Thank you.
Mr. Robinette.
Yeah, Dave Robinette with iCar. So interestingly, as I have in my career in the collision repair, worked with customers, it's interesting. I have to explain to the customer up front, and I think this is where this conversation is going on almost every point we've talked about, is that an upfront conversation with them so that they understand what they're getting into. I've oftentimes used the term that the accident, if that's what we're talking about as collision repair, occurred. That was an event that happened. But the collision repair process is a process, and it does take time for that to take shape and to develop. And so we've been tossing around terms about tear down, disassembly. There's a third term out there in the collision repair industry called blueprinting. And the blueprinting process is deemed to be the most comprehensive discovery of all damage on the vehicle. It's not uncommon for a car to be hit and have the primary point of impact be the focus, but then there can be transferred damage with energy out through the vehicle. And there could be damage elsewhere in the vehicle that you can't find unless you go through a very comprehensive disassembly and measuring process and all the scanning that has to go on. And it becomes quite a process to put that all together. Not that it can't be done. In fact, it should be done. And we're encouraging that to be done all the time. So to let a customer know what this estimate will be, some people are moving away from estimates to what they call damage reports because it connotes more detail, more accuracy, that sort of thing. That's an easier number to get to once you've had a chance to go through that whole process and to put that together in a comprehensive way so that now I can say, well, pending further information that we find upon the repair process, this is what the bill is likely to be. And of course, the stopgap on that for most collision repair is maybe the total loss value of the vehicle. Usually that's where it kind of stops. And a lot of times the blueprinting process will stop once they hit a certain dollar figure, which might be considered to be the total loss value threshold, if that's the case. Anyway, that is just the understanding of what the process is and why it becomes somewhat difficult. This here that talks about being specific as to how much damages there's going to be and get that all written up and hand it to them. And then what it's going to take to reassemble the vehicle. I love the conversation about the transmission or some of the other things. I can tell you, I've had cars that were T-bone right in the door. And in order to find out all the damage, I had to take the door off. Well, door can't come off unless I start cutting holes in it. And once it's off, it's not going back on. And we're committed. So it's an interesting little challenge about, I'm going to tear down, I'm going to disassemble, I'm going to blueprint the vehicle and give you this information. And the portion of the vehicle becomes the question and that gets very, very nebulous.
Well, I want to call out Jack on this topic because the day before we crafted this presentation, we had a conversation about this very item, about the tear down. And Jack, you need to publicly acknowledge that I admitted then, you're right, we do need to work on this language. We just didn't get a chance to do it. So I was right. I will commit. We are going to work on that language to address,
I appreciate that.
inspect,
Thank you.
diagnose, examine, blueprint, tear down, whatever. Damage relevant to the area of impact, maybe something along those lines. Just,
Yeah, I
I'm
think
throwing
that's what I
things
was
out.
driving
We're
at.
all gonna, yeah. We've heard that clearly. We heard it clearly before the presentation was drafted, but
I just tried to put a different spin on it. That's all.
I think part of the problem is a certain somebody was going on vacation right after that meeting where that discussion was had and was gone for a couple days and did not participate. And that person shall remain nameless. And didn't get a chance to follow through on his commitment to Jack to change that language.
Fair enough. Way to go, Jack.
Just one real quick comment though, because I know that it's been stated multiple times, if you can't put the car back together in the condition, there is a provision for that. It's not being added. It was always there. It's actually section C that says of applicable notification that the act of the tear down might prevent the restoration of the vehicle to the condition in which it was provided by the customer. It's understood that in collision specifically, when you're having to cut something off in order to inspect, it's known it's not going back together. But disassembling a transmission in most instances to determine what's wrong inside, there's somewhat of an expectation to put it back together. Yes, there may be some instances where it may not drive afterwards, but you still have to reassemble the car. It's not give them the transmission in a box and here, have good luck. If the customer is going to get a part of their car back in boxes, they need to know that.
And to your point, that's exactly what I would say. It's, once I do this, we're going to pass the threshold of point of no return. So know this, if I get into it, do you want me to do it?
Again,
So,
disclosure.
right up front. Yeah.
That's
Okay.
what it is all, disclosure up front.
I want to allow for others to chime in. Pete's been waiting very patiently, and we have others who are wanting to get in for public comment on the WebEx. We'll get to them shortly. I want to give Pete the next chance to make some comments. Welcome, Pete.
Oh, okay, all right.
You did it.
I'm on.
You passed the test.
Can you put the first slide back up again? Okay. Pat, the first thing is that we can't have an interpretation of whatever we're writing. We have to have it exactly what it's going to be. You talked about it's up to interpretation. There is nothing up to interpretation. When something happens in the future, it has to be absolutely clear. No subjective, everything has to be objective. The second thing of it is you made the statement that you get this stuff from other agencies or other businesses where they tell you what you're going to have to pay out of pocket in addition to their charges. And I will tell you right now that you're incorrect. When I go to my optometrist and I sign to get my eye exam and my glasses, I have to sign and acknowledge that they may not get paid everything from my insurance company and that I'm going to have to pay the difference. And I don't know what that difference is, and they don't tell me what it is. The same thing when I go to my dentist. I have to go and I sign those same things. And by the way, that's what we use on our authorization forms that we supply to shops, because the insurance companies don't tell you what they're going to pay, other than the deductible, which we always tell the customer what they're entitled to. The next thing, this is the 6-day deal. Dave Kusa, you're absolutely correct. I don't think the BAR or anyone else has the right to tell a repair facility or anyone else how much time they have to give for a customer to make a decision, other than the fact to say, I'm going to give you this much time, and it's a business decision for that business to tell the customer and set their own priorities. You say something, let's see, oh, where is it? Customer, I can't remember which one it is because I can't see all this stuff up here. But the tear down, in the case of the 6 days, where you talked about the insurance code, this is very specific within the insurance code. This section, if an insurer chooses to exercise its right to inspect the damaged vehicle, the insurer shall, within 6 business days after receiving notice of the claim, request of the claimant that he or she make the vehicle available for inspection by the insurer. You'll notice that this is within 6 business days of receiving notice of the claim. That's not 6 business days from whenever the hell the insurance company wants to decide that's going to be. We decide we're going to look at it, so we got 6 business days to look at it. The date that customer files that claim, the clock starts running. And there is nothing in there that talks about the repairer. The repairer has no piece of that in the insurance code. So please get that correct, understand. We're talking about 2 different things. So I think that I'm not going to go over a lot of other stuff because everybody has done such a great job chopping you up on this stuff. But the other problem is that when we know, right now, we know for sure that the auto body industry cannot repair a vehicle to a subjective position of the way it was before, because we don't know the way it was before. The other issue is the manufacturer tells that auto body shop how to repair that vehicle. It very, very specifically tells them. They don't have a whole lot of choices. So that's the way it's going to get repaired. And if the insurance company wants to put aftermarket parts on it, or they don't want to pay for something, that's not the body shop's problem. That is the insurance company and the consumer's problem. Remember your own regulations. Identify who the customer is, and the customer is never the insurance company. And it's not the auto body or the ARD either. Neither one can be the customer. It's the person who presents the vehicle for repair, or the registered owner of the vehicle, however you want to calculate that. The second thing of it is the insurance company can't represent the customer in that body shop. They can't tell the body shop how to repair the vehicle. And there have been numerous body shops that fell into that trap and got stuck for millions of dollars because the insurance company doesn't repair cars, the body shop does. These are factual things. So, and in addition to that, and I got my own notes here, in addition to that, the body shop can't represent the customer with the insurance company. The insurance code is very, very specific on who can represent that customer under their policy. And the authorized people that are listed in the insurance code, and that's section 2695.2C, if you want to look at it, just look it up for yourself. The authorized people are family member, an insurance adjuster, that would be an independent adjuster hired by the insurance company. A public adjuster, that would be an adjuster that the customer hires to represent them with the insurance company, so like under the right of appraisal. An attorney or a conservator. That's the limitation. A body shop doesn't get to negotiate for the customer. They have to do that themselves. When that body shop does the disassembly of the vehicle, they research the the manufacturer's repair specifications, and that's how they write their repair plan. When they submit that repair plan to the customer, that is their charge. And I think Dave Coos has said it very well. That's what they expect to get paid. A third party doesn't get involved and tell the body shop or the auto repair dealer what they're going to charge. That is the auto repair dealer's decision. And if the customer is smart, they'll go to their insurance company. That's their responsibility to negotiate with that insurance company, not the body shops. And you can't hold the body shop accountable for what the customer is supposed to do and protect the customer or the consumer at the auto repair dealer's expense. And that's what you're trying to do here. You're putting the body shop or the auto repair dealer in the center of a conversation that they have no part in. They're not a part of that contract. The insurance company has a contract with the customer. The auto repair dealer has a contract with the customer. The customer is responsible to the ARD. And Patrick, when you were talking about the warranty stuff, you take a vehicle into the repair shop for a warranty, and they're going to repair the warranty stuff. The customer knows that that there's no charges because that's a warranty. But if there's additional charges, they find something else, that's the responsibility of the ARD to get authorization for that supplemental payment from the customer. So the customer knows what they're going to be responsible for before the fact. That's already in regulation. That doesn't need to be dealt with. You're trying to put a whole lot of things in here that have nothing to do. And here again, I think Dave Robinette said the other thing. We don't know what the damage is entirely. In other words, we kind of have an idea of where the damage is. It's in the left front or the right rear or wherever it is. But in a unibody car, that damage travels. And we don't know what it is until we disassemble it and measure it. And as Jack said, we don't want to be in the position of having to write supplemental teardowns every damn time you turn around. We want to be able to say that this is the repair cost. We've torn it down. We've prepared a repair plan, and this is what it's going to cost. And the only changes would be if we just find something that cannot see. That's my
So-
2 cents. Thank you.
Honestly, I don't disagree with what you're saying, and I don't know that that's putting a body shop in the predicament that you're describing. Disclosing to the consumer what the financial responsibility is versus the insurance's responsibility is not stating that the auto body shop has to repair the car the way the insurance wants to pay for it. That's not what that's stating. It's not saying that because the insurance company is unwilling to authorize the payment for the repairs that you're recommending, that you have to fix it per the insurance. You can decline to do the repairs altogether or tell the consumer that this is the way you're willing to pay the car. This is what the insurance is paying. This is what you have to pay. They can still go argue with the insurance company as to whether or not they're going to cover the additional cost. It's the disclosure to the consumer so that they're aware that the insurance company is not paying that portion, because it's reasonable to expect that when I pick up my vehicle, the insurance is covering it, especially if nothing's told to that consumer. Nowhere in there is it saying that the auto body shop has to repair the vehicle pursuant to the estimate that the insurance company is providing. No one's saying that you have to degrade the repairs that you feel are appropriate, but you have to disclose to the consumer what those repairs are, what they're responsible for, and allow them to make an informed decision. Do I have those funds to pay for this? Do I have to take the car home and think about it? It's not fair for them to pick up a car with a, you may be on the hook. They have to, it's disclosure. It's not dictating how you repair the car.
Isn't it obvious that when the customer is made aware of what the insurance company is going to pay, how much they're going to have to pay of it? They are unable to do simple math. The insurance company tells your bill is $10,000 from the repair shop, and the insurance company says we're only going to pay $6,000. Why is that the responsibility of the body shop to try to figure out and to explain to the customer what the insurance company's already told them? You owe $4,000 in addition to, well, you owe $3,000 and your deductible if it's $1,000. You're assuming that the body shop or the auto repair dealer has all the responsibilities and the insurance company has none. You're putting the auto repair industry in a no-win situation here. You've got an insurance company that is responsible for the payment. They say in their policy that they're going to pay to repair the vehicle, as Bill said, to pre-accident condition. Well, we don't know what pre-accident condition is, so we can't stipulate that. Maybe the insurance company has a better idea of how to figure that out, but we don't. But the point being is that when that insurance company makes a decision and they send an estimate to us, and we send that estimate to the customer, it's relatively simple. You owe the difference. Dave's mechanical shop, when he says it's going to cost $10,000 to replace that 10-speed transmission, that's what he wants to get paid. And the customer, that's what they pay, or they don't get their car back. You're trying to put the auto body shop in a different set of circumstances that the general repair industry doesn't have to put it up with. And of course, you guys are going to get there because the warranty issues are coming up. But the point being is that you're trying to put the auto body industry in a babysitting position for the customer, and that's not our job.
Thanks for your comments, Pete. We'll take them under advisement with all the others.
Thanks, Bill.
Thank you, Pete. Let's open it up for some additional comments. We've got another one in the room here. Come on forward. And then after that, we'll go to the WebEx. Jean, you also? Oh, and another. I'll get to everyone. I'm going to try to go to the WebEx next just because they've been patiently waiting.
Hi, my name is Tony. I'm with the insurance industry, so it's not a point of, I guess from my perspective, of getting a tear down bill for 30 hours of tear down from a rear bumper hit from say a 2000 Dodge Neon. We can't see all the damage under the bumper cover, so it's a tear down, and then all of a sudden the shop disassembles almost the whole freaking car. That's not what we would expect for the customer. That's not something that we would want to pay for, because a reasonable person, if they take that bumper cover off, get the trunk lid open, take off some of the interior trim, can tell that car is total if there's floor damage or rear body damage. We're getting situations where we're getting 30 hours of tear down and then 40 days of storage charges because they want to let it sit there. And I don't begrudge a shop, and we have great working relationships with a lot of shops. And it's the idea of a few bad apples are probably causing more of the problems that you're getting the complaints for. So finding that middle ground where there's some kind of documentation as to what the charges are going to be, as to, yes, we're going to disassemble just the rear section here, just to this point, just so we can see further, as opposed to all of a sudden 5 days later, oh, we took apart everything through the seats, all the interior trim for 30 hours. It doesn't take anyone with any bit of knowledge to already have the argument that that 2000 Dodge Neon is only worth $3,000 or $4,000 at most. All the labor you've put into it has already totaled the vehicle. So it's kind of fighting those issues. That's pretty much all.
Thank you, Tony.
Thank you.
Moderator, could we open up for a few comments from the WebEx attendees? And then I'll go back to some additional comments from the in-person.
All right, this is the moderator. I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment, you can either click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or you can use the raise hand function. And it looks like I do have a couple people who have their hands raised, so I'll go in the order that they're received. First, I have Tony. And Tony, I'll request to unmute your microphone. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
Hi, I have a question. For the teardown estimate, what happens when the car comes in with a repairable estimate from the insurance company? Do you still have to write a teardown estimate even though you have a repairable estimate?
So with the question that you're asking, if I understand it correctly, if it is still your shop's responsibility to determine whether or not a teardown is necessary to provide the customer with an estimate. If you adopt that estimate as is, then the expectation is you're fixing the car. If you feel that you can fix the car based on that estimate, you can so choose to. But if you determine that you need to do a teardown to provide them with an estimate to repair the vehicle, then that is the path that you should take. So it doesn't restrict you one way or the other. You have to determine what's the proper means necessary to provide an estimate to the consumer that you can fulfill as part of that repair process.
Okay, so even if the car comes in with the tear down, I mean with the repairable estimate, and you in the right you put repair vehicle per insurance estimate number, whatever, and you start taking the car apart, you find more damage. Now the shop's on the hook for it, or
So I believe you're asking if you start to repair the car per the insurance estimate and determine there's additional damage beyond what was included on that estimate.
correct.
So if it goes into something that's at that point that you should be stopping, it would be a supplement. Whether or not you can still go through the insurance company would have to be determined, or if it's going to be straight with the consumer, if they've already received payment, that would have to be determined. But you can at that point stop. You would have to obtain additional authorization from the consumer before you can proceed.
Right.
It's not that you would be on the hook to perform those additional repairs.
Right. So I guess that that answers my question. But now, how about a different scenario where a car comes in with a repairable estimate? You don't provide a teardown estimate because you have, obviously your R9, a front bumper and two headlights, and they have to, to repair the hood or replace the hood, and you take the car apart, and now the car becomes a total. Is the insurance company responsible for the time you put into disassemble all the stuff that they had on their repairable estimate? Does that make sense?
Trying to make sense of the question.
So I think the question is, and I'm just going to create some random examples just for discussion purposes. So you're saying you receive a vehicle, a consumer brings a vehicle in with a repairable estimate from an insurance company to fix X damage for $5,000.
Correct.
You begin to disassemble the vehicle and you realize that it's going to be much more than $5,000 to fix that vehicle. You prepare a supplemental estimate to supplement that estimate for $5,000, and now the vehicle's a total loss. The insurance company is obviously not going to pay to, it's going to be a messy situation, is because there's going to be question as to whether or not you're entitled to the $5,000 that was on the original estimate that you started to repair under, because you didn't complete all those repairs. So you're going to have to negotiate with the consumer, who's going to have to negotiate with the consumer, with their insurance company, what you are going to get paid. And it's going to be problematic, because if you didn't do all the repairs listed for that on that $5,000 initial estimate, you're not entitled to all that payment.
No, I get that. Yeah, I wasn't asking about the first, do I get paid the 5,000? No, but
Right.
because the car had a repairable estimate, and we did, remove the bumper, we removed a headlight, or we removed the fender, which was all listed on the repair estimate.
Right.
The car totals out. We can still charge, whatever, right? Like if it's an hour to remove the fender, you charge 0.5 because all you did was you removed it, you didn't reinstall it.
Yeah, you're going to have to negotiate with the consumer what a fair amount for what labor you did perform is, and what parts you used, if any. And then they're going to have to negotiate with their insurance company as to what they're going to pay for that.
Okay.
And that's going to come out of their total loss estimate. It's messy what you're describing, but you can get there. It's just a lot cleaner, like a lot of this panel, for you to perform your own tear down, disassemble, and provide your own estimate. But
Okay.
either way works for whatever business model, just as long as the consumer is fully aware of what they're going to have to pay and what the insurance is going to have to pay.
Oh, but I mean, with every insurance company is kind of different, right? So you have one insurance company saying, well, we're not going to pay the tear down. Well, how'd you expect me to know if the car's a total or not?
Right.
Or how'd you expect me to know what else is going on inside the car if we didn't tear it down?
Yeah, that's the dilemma we're looking to try and provide clarity to here. And your feedback is excellent. Thanks, Tony.
No problem. Thanks for taking my comment.
Moderator, any other comments on the WebEx?
Yes, this is the moderator. We have see, 1, 2, 3, 4 more comments on WebEx. So I'm gonna keep going in the order that they were received. Next we have Rich Sellover, and Rich, you'll be I'll click the request to unmute button. Please click the unmute me button when the prompt appears on your device.
Sounded like it unmuted.
Yep, you are unmuted.
Okay. Thank you, gentlemen, for this meeting today and working through this thing. I've got several different thoughts on this. I think the first one that I'd like to start with is we're looking at 3 pages of regulation, and we appear to try to be blending an existing regulation that was written for the mechanical facilities and morphing it over to the collision industry. And that might not be the right way to approach it. Maybe we should go back and approach it with a collision teardown or inspection procedure separate from the mechanical.
That's an interesting proposal, and yeah, that's something we'll definitely look at and consider. A lot of heads are nodding around here.
Additionally, ever since BAR was formed, and prior to that, we have always kept the insurance industry away from the consumer as far as requirements for approval for repairs, how repairs are going to take place, everything else. This appears to me to be the beginning of morphing the insurance industry into a consumer position. And that's a grave concern of mine.
Thank you for the additional comment.
I'm not quite done yet.
Okay.
That's only 2 of 6, right?
Yeah. About 1.5 years or 2 years ago, the BAR took on a storage and towing study, if I remember correctly. And part of that study, it was determined that it was not determined, it was presented that storage could not be charged while a vehicle was under repair. Immediately, the insurance industry played that card to their advantage and started writing estimates that kept vehicles repairable when anyone, Stevie Wonder, could tell the vehicle wasn't repairable. But they did it so they could prevent having to pay the initial storage until after the teardown and everything else was completed. And that took, I would say, on average, especially during COVID, when we saw major insurance companies running a 2 to 3 week backlog on their total loss units, that took a great amount of storage money out of our industry and cut those losses on their end. Again, I see this 6-day deal coming from the DOI. I disagree with it, much like Pete said. Again, we don't want to blend these 2 industries together, but having the insurance industry keep the vehicle under repair, much like Tony just spoke to, is what's prompted a lot of this teardown concerns, and like insurance Tony spoke to, that's what's prompted some of the body shops to get a little heavy-handed with both the teardown charges and everything else, because they took the storage essentially away from the onset of the claim.
Storage is scheduled to begin discussion next month as we start crafting regs for that, and we'll certainly be looking at the input on this. I will say that there's no regulation or statute under the Bureau's authority that requires a shop to work on a vehicle. So if a vehicle comes in that's an obvious total loss and the insurance is trying to motivate you to do a tear down, it's certainly your right as a business owner to or manager to say, no, thank you, we're not going to work this car, but we are going to charge you storage from the day it arrived here. And that's certainly within civil code, vehicle code, and our our statutes.
Okay. Um, and much like to Body Shop Tony's comment, it's quite often that doesn't occur until after some blueprinting teardown, initial teardown, a little further, you can anticipate, but you can't prove until after a little bit of teardown has taken place. I think for the most part, my biggest point is when I look at this, maybe we should separate the two. Keep the insurance industry out of it. Keep this to be a consumer regulatory commission between the provider and the consumer.
That's a great point that we'll take under consideration.
Thank you.
Thank you.
All right, moderator, can we go to the next one in line?
This is the moderator. Our next individual is John Dietsky. I'll request to unmute your microphone. Please click the unmute me button when the prompt appears on your device.
Can you hear me?
Yep, we can hear you.
All right, great. Thank you for doing this. Unfortunately, I wasn't able to hear much of the audio at the very beginning, but I did review your sheets and kind of understand where this is going. And I got to agree with Rich right off the bat, is why is there an insurance person in that room? The BAR is for the consumer, not for the body shop, not for the insurance company. They are there for the consumer. Am I wrong?
That is correct. We are here to regulate the automotive.
Why is there an insurance company in there?
Well,
All they
this
want-
this is a
they-
public meeting, so everybody's entitled to attend and weigh in on the regulation.
All right. Okay. Well, I would like to know when all these meetings are going to be, and I know you did let me know, but I want to be in those hearing rooms with those insurance companies so I can put it right back in their face, what they've been doing, what they keep trying to do, because Tony's right, Rich is right. Everything the insurance company does is to hinder us from doing what we want to do. Now, I love what some of the things you guys are saying when it comes to well, you just deal with the customer. That's not how this industry works. But I've been telling my staff for the last 2 years, I'm about ready to just not even deal with the insurance company and deal with just with the customer and let them fight that battle. But you know what will happen? Cars will sit and rot because the insurance companies don't care. And if somebody don't stand up for them, like a body shop that wants to fix the car right, they're not going to get the car fixed right. I have written, and Rich brought this up too about the cars coming in. They write these estimates. I get repair estimates for $400 that end up being $11,000 later. Then I got to explain to the customer that their insurance company did that on purpose because they just want them to cash the check. Because we all know 7 out of 10 cash the check and never fix the car. Those are real stats. So when COVID hit, that just gave the insurance company a bigger license. They started it years ago. I'll even name insurance companies. All states started it years ago. Just having people come to the drive-in and hand them checks. All of a sudden, we didn't see any Allstate work. Customers were taking the money, especially at Christmas time. So really what you guys need to be doing is attacking these insurance companies. They're misleading these people, the consumer. They're writing terrible estimates on purpose. They're not even putting the standard things on there that needs to be done. And here's a $2,000 estimate, and $14,000 later, their car's being repaired, and they're wondering what just happened. The insurance company wrote me a check for $2,000. How did it end up 14? Well, you can imagine what the insurance companies is telling them. But we have to prove to them that here, this is what we found. Come on down and let's take a look. So there's a lot of things that I didn't hear the whole meeting, but Rich is right. You guys should be working for the consumer, not for, I don't know why the insurance company's in that room. I just don't get it. Tony brought up the insurance, Tony. No, I don't know who's tearing down cars for 30 hours. That is ridiculous, Tony. But yeah, I doubt that's happening. I don't believe that comment. I think that's ridiculous. If, you know, if you want to require a tear down, especially with these cars today, and the way the insurance companies are, I'll give you a great example. I can even send them to you. I can send you original estimates that I tore blueprint at, you know, damage repair, right? The plan, $14,000, $22,000 repairs. Here you go to the insurance company. They come back with $6,000. Then I got to write 5, 6, 7, 8 supplements to get back to the $22,000. It's a waste of time. And I got to communicate all that to the customer. And at any given time, they could say, yeah, stop, I don't want to do it. And then we're stuck. Anyway, I would like to be on the list when these hearings are in person. I want to be there. I like to be there. I'll fly there every meeting, because this industry, we're losing people left and right. We can't find anybody to even come to work in this industry anymore because of what we have to deal with insurance companies. Right now, I have at least 15 cars sitting at my shop with red flags on them, waiting for insurance companies. I got one that's been there for 3 weeks, and we keep calling them and they keep going, well, we're working on the estimate. We're working on the estimate. How much you want to bet that car totals in week 4? And then they're going to try to tell me I can't charge storage. Anyway, we got bigger problems, and I don't know if you guys have the right people in the room, and I would like to offer free of charge my opinion, and I'll be up there anytime you guys have a hearing regarding auto body. And Rich is right. There has to be something different than automotive. We're not tearing down a transmission. We know those guys know every component inside a transmission. Car gets hit in the left front, it could have damaged the right rear. Right? Thanks for listening.
Thank you, John. Moderator, next up.
All right, this is the moderator. Next we have Craig Rayburn. And Craig, I'll request to unmute your microphone. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
You hear me okay?
Yep, we can hear you.
Okay. So I just had a question referencing Tony's example, the $5,000 original estimate fixed a car. I'm going to just play the devil's advocate, and let's say the shop takes the car in, cashes the check. Nobody hears anything from the shop for 2 weeks. Then they contact the insurance company with a supplement, and now the supplement is another $5,000, and it might deem the car a total loss. For everybody on this call and this webinar, what's everybody think is owed on storage? I hear crickets.
Yeah, you do hear crickets because, and I know the example you just gave happens a lot, and we deal with those, and we deal with them on a case by case. There's certainly some problem on what you're describing with what the repair facility did, that they've cashed a $5,000 check and questions how much work has been done, how much storage is actually accrued. Is there any storage warranted? Because it sounds like there may not be. Again, it's on a case by case basis. So I can't opine on that, on what's owed there.
But does everybody think maybe it should be less than 2 weeks? I mean, I get it. It takes a little time to take the car apart. You know, there's scheduling, there's weekends. I get it. Like the last gentleman, John, just said he's got 15 cars. I get it. But, you know, if it took 2 weeks, does that mean the insurer owes storage for that whole 2 weeks? You know, as far as the insurance company knew, the check got cashed. Well, I assume you're fixing the car or at least working on the car if you cashed the check.
Right.
So I appreciate your thoughts.
No, I think your point is very valid and is part of this opportunity to make the industry better that we're facing here.
Thank you.
Thank you. Any more?
All right, this is the moderator. Next we have individual identified as Jeff, and Jeff, you'll be given, I'm sorry, going into board. Speak for the other board meetings I do. I'll request to unmute your microphone. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
Okay, can you hear me?
Yep, we can hear you.
Fantastic. I understand that there's changes taking place. Um, Unfortunately, we're in a place where in our industry, the consumer does not negotiate with the insurance company. In fact, it would probably work in your favor if the owner of the car was there and the insurance adjuster was there and they told them what they were going to pay for or not pay for. But historically, our industry has two professionals looking at the car. One is the estimator or manager or whoever's at the shop, and the other professional is the one sent over by the insurance company. And the issue is the insurance company is requiring or requesting that we disassemble the car further. And if you can imagine, in our current state, we have a shortage of technicians. In fact, most technicians are making several thousands of dollars a week, and they're not going to work for free. And we can't afford to store cars for free either, because each spot in the shop may be as high as $200-300 per day. I mean, you rent for body shops is astronomical. My only real concern is that this is not the dental industry where insurance pays $1,000, you got a $1,500 bill and you're paying $500 out of pocket. It doesn't work that way. And I don't know how to correct it. I just know that consumer to insurance company, it's nothing good's going to come from it.
All right, thank you for the comment. Moderator, are there any others on the WebEx seeking to speak?
This is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. And I'll circle back to those in the room because I know that there were some hands raised. So Jean, why don't we go to you next? And then the person in front of you.
Thanks. Hi, this is Gene Lopez with Seidner's Collision Center. And there's so many conversations that are going on. I was on the phone with SICA, the Collision Industry Electronic Commerce Association. SICA offers a lot of behind the scenes work for the information providers. They offer codes. In this particular case this morning, it was talking about ADAS calibration. And I mentioned that I was coming into a meeting and we were going to talk about teardown. And I was immediately attacked. It's, Gino, it's not a teardown, it's a disassembly. You have to tell the California Bureau of Automotive Repair to remove the word teardown. And so I've done that. I understand teardown. And I think that what we're looking at in a lot of cases are two different scenarios in the collision repair environment. One is in a DRP environment and the other is a non-DRP environment. And so I think that's what we're up against in some cases. While I wholeheartedly agree with what Pete had to say about the insurer and the consumer making a decision on what parts are going to be replaced, whether the OE or aftermarket. In a DRP environment, which the company I work for is probably 95% DRP environment, and it's in our best interest that we support the consumer, that we go to the consumer and say, look, we wrote an estimate, it has these parts, but your policy won't allow those parts to be put on your car. Let's take a windshield, for example. There's an OEM windshield and there's an aftermarket windshield, and the cost difference is probably $300. Your insurance policy is going to have the aftermarket windshield replaced on your vehicle. If you would like to pay the other $350, we'll work on that with you. And so that's how that scenario goes. We have to be an advocate for the consumer. In many cases, it's just because that's the environment that we're in. But when it comes to storage, we have to be very, very careful. and I have to agree with most of the group that that 6-day window is, can turn into 10 days overnight. And we have to be very, very concerned with that. I mentioned, I think it was to Chief DeRay earlier today, some of these pre-authorization checks or repair checks that claimants receive are based on photo and artificial intelligence. So right now you can take photos, 4 corners of the vehicle and 3 photos of the direct damage and get an estimate, right, from an insurance company. Very dangerous, because some of those claimants are going to take that check, that $1,800 check, and not know that it's really double or more than double to repair the vehicle. So we have to be concerned about that as well, when we're looking at what the consumer gets, the information the consumer gets, and what the actual disassembly estimate or teardown estimate or teardown authorization, which is another thing that we haven't brought up yet. Or did we? I don't think teardown authorization was in this conversation today, which goes back, Patrick, which goes back to we're going to disassemble your vehicle. And in that authorization to disassemble your vehicle, we may not be able to give it to you back. And that's an important part of this conversation, is the disassembly authorization or teardown authorization. So a lot of conversation needs to continue, and it looks like there will be mutual purpose, right, on all sides, the consumer, the insurer, and the repairer, and mutual respect when we are in these conversations, because all the parties, the state of California, insurers, repairers, and consumers are all involved here. So thank you.
As always, thank you very much, Gene, for the very insightful comments. The teardown authorization, I think, did come up ever so briefly in response to a comment or question from Mr. Kusa here, but not a lot of talk on it. Yeah. There you are. Got up there before I could get back to you. Good. Nice to see you. There it is. You got it.
There? Okay.
Mic's on.
My name is Oscar Moreno. I own a body shop in Fairfield, about 45 minutes from here. And going back on 3352, I do have some comments, and I share the opinion of some of you here in the room on how the tear down, partial tear down of this regulatory adjustment should be. But one of the things that I want to bring up to your attention is, in my shop, the average year of the vehicles that we work on is probably 4-year-old. We want to make sure that we have the right wording there to where possibly it's not a tear down no more. I think tear down might have come in back maybe in the 70s. We are now doing a complete damage analysis. And the way we're doing this complete damage analysis is by going into the repair manual from the vehicle manufactured and putting it on the estimate. Many times when we do this damage analysis, let's say that if we have a front bumper damage, and it could be damage as small as a dent on a bumper. By the time we disassemble the vehicle, we might take that bumper off and we look into the repair manual. That bumper might have radars. That bumper might have parking sensors. That bumper might have parking assist, or some of the vehicles that we're seeing nowadays, they park by themselves. So I think that the wording there needs to change, and we need to keep in consideration that nowadays we're not working in vehicles that are let's say 30 years old. Most of the vehicles that we work on, they're newer vehicles with newer technology. Literally, they're computers on wheels. Okay. Going back on 3352 H on pre-loss condition, as has been brought up before, there is no way that we can go back to pre-loss condition. I think that's pretty clear, right? Damage analysis would be some a language that might be used for body shops. And I agree with some of you that have called in to where body shops and mechanic shops should be seen and separated, at least in the language, for the tear down and taking vehicles in and, you know, being repaired. As far as the days of the 6 working days, I think this is going to bring a lot of issues to the industry. My shop is located in an area to where I pay a lot of money per rent. And if I was to have vehicles in a frame rack waiting for 6 days, 6 business days, is going to be really bad for small business. I feel like 6 business days is too long of a time. I feel like if we communicate with the vehicle owner, let them know how much it's going to be, and if the vehicle owner feels comfortable enough to give us the authorization to repair, we should get going on the vehicle. Many times consumers do not have rental vehicles in place, and many times they need their vehicle back as soon as possible. 6 working days is too long of a time. As far as the getting the body shop and the insurance company together, I think that should be completely separate. I think it's well defined who the customer is. And we should, as a body shop, we should work for the customer. The moment that we get the insurance company to try to minimize cost, many times, and I can tell you for my personal experience, by the time we minimize costs, what is a risk? We got to ask ourselves, what's a risk? Are the occupants being a risk? Many times that's what ends up happening. And of course, the quality of the repairs diminish. We got to go back to 3365 that talks about getting the vehicle repaired back to the manufacturer specifications, and we need to make sure that we understand that section, because if we go back and repair vehicles back to the manufacturer specifications, then I feel like it's going to prevent a lot of issues with the insurance company. We have, or the insurance company industry has one goal, is to minimize the cost, but sometimes the price is too high to pay, and that is getting customers and vehicles that are not safe. The body shop should not be representing the customer, as the customer who should be representing themselves. We, as a body shop, based on the damage analysis that we get from the vehicle manufacturer repair manual, we present the proposed repair, and it's up to the customer whether to say yes or no. And we're not going to know what the insurance company is willing to pay or not pay. Many times, as we tell the customer, for example, your repairs are going to take $5,000, the insurance company has approved $4,000. There's a gap of $1,000 plus your, let's say, $500 deductible. Mr. Customer, would you like to proceed? Many times, the insurance company also tells us, look, after we get photos in process, we'll revise and then we'll see if we can cover more. So that's something else that we need to consider, that many times, I get it, carriers, third parties might need in-process photos. And the body shops that I do know have no issues providing photos or documentation proving that the work was done. But to be able to reproduce those photos as proof, we need to get the customer approval to actually do the repairs and get those photos, or take those photos in process. I think the most important thing that is for me is, please don't get the insurance company involved in this. We know who the customer is. I like to work for the customer in the customer's best interest. Thank you.
Thank you. I didn't catch your name at the outset. What was
Oscar.
Oscar? Thank you so much, Oscar, for the comments. Yes, come forward.
Forgive me, I on vacation this week and I just came in from the golf course. Last minute and all. I've been in the industry now about, since I was 17. I'm 65, you could do the math. Long time, and closer to a half a century than 40 years. A lot of the things that we are discussing here, the way I interpret it, has to do with the fact that all of us in this room that are in the industry have we do a lot of things that are to appease the insurance companies as well as the owners of the vehicles, as well as our own facilities that we're running. I've been running the shop that I'm running for 40 years now, and it used to be that you would just write on the repair order, repair as per insurance coverage. And we have that ingrained in our systems here, mental systems, that we have to do that. The bottom line, the way I see it, and first of all, to address the idea that the body shop should have to let the customer know what the insurance company is paying because every other industry does it that way. Well, the fact of the matter is, I've never been to the dentist, or excuse me, I've never been to my insurance company yet to get an estimate on a crown. I've never been to the insurance company to get an estimate for an eye exam. I go to the places that are the experts. I go to the dentist, I go to the eye inspector or the optometrist, excuse me. When we deal with these things regarding the body shop industry, if you wind up having to go because of a complaint, or let's say it gets escalated to the point where it's actually you're going to court. Every term that I've ever heard given to the body shop in those situations is, you are the expert. You're the one. I've heard this from persons from the Bureau of Automotive Repair as well. You are the expert. You're the one that's supposed to know. It seems like the only one that doesn't have to buy into that would be the third-party payer. An example is when we're talking about how long a car can be sitting in a shop waiting to get authorization. I'll give you a little example. In August, at one period of 1 week, I had 7 cars being repaired, and I had 21 cars that have gone through the blueprinting process, uploaded to the insurance company, and we're waiting for them to reply. And they will, and I don't want to get too heavy into this because it can go a long time. But the fact of the matter is, 21 cars waiting to get approval when the customer wants to get their cars fixed. And they sometimes go 10, 15 days. And it's a balancing act, because you don't want to, I would never necessarily bash a person's insurance company nor a competitor to make myself look good, to make our shop look good. You don't want to do that. It's a bad way to do business, in my opinion. However, educating the customer and showing them what needs to be done and why the estimate is twice of what the insurance company wrote, because again, they're not the experts. They're not the ones that know how to repair the vehicles. it ties it up. 6 days is crazy. We can know within 24 to 48 hours that a car is a total. In some cases, we know the moment the tow truck has dropped it off. It's a total loss. And the insurance company will say, well, let's tear it down. Or you get the estimate all written up and they'll say, well, we're going to resource other part vendors. Next thing you know, you got $4,000 worth of parts coming from Florida, Arkansas, all these other places, which is ridiculous. And all it is a way to buy time to not have to pay the storage. It needs to be clarified, or it needs to be put into a place where the shop at least is on even ground with in benefit to the customer. At least that's the way I see it. I don't have any DRPs at all. 0. 40 years at that shop. We do a lot of business. We do a lot of good business, but we don't. I think what the industry, as far as the body shop industry, needs to understand is what the laws are. I'm grateful for the Bureau of Automotive Repair. There's a lot of good stuff there that we may not have known. However, I didn't get my first visit from anybody from the Bureau until I think 1998. And I've been working at this shop since '84. There wasn't a big push, I guess, for body shops. I don't know, maybe more about smog and stuff like that. But all I'm saying is I know that there's been people that have, or shops that think that it's bad, or that the BAR is trying to do a bad thing. I think BAR is trying to do a great thing. But I do think we need to have that communication where we all discuss what really goes on in the real world on how this stuff goes, because I think and I think it's just inherent in all of us. I believe that we have, for so many decades, we just think that there's certain things that we have to include the insurance company in. I don't have to include my employer because the price of beef went up. I don't. You get what I'm saying? Does that make any sense at all? I mean, I just think that we have to do a lot in our industry, in the collision repair industry, that is really not our job to do. I get notified by my dentist after I've already had my crown done. Okay, your insurance company's paying $800 and you're responsible for $457. Well, they didn't tell me that before. They didn't tell me that before they got started. They said, you need a crown, get it done. And I didn't go to the insurance company to have them write the preliminary estimate. I don't understand what an insurance company is writing preliminary estimates for in the first place. It's another issue, but anyway, I'll get long-winded and I don't want to do that, but I hope I made a point or two.
Yeah, what was your name? I'm sorry, I missed it.
My name is Jeff.
Jeff, thanks again
you.
for your comments. Great stuff. We have another comment in the room or WebEx? WebEx. Okay. We'll open it up for another comment from someone remotely attending via WebEx. Moderator, can you do that for us?
Sure. Looks like we have a comment from Rich Sulliver. And Rich, I'll request to unmute your microphone. Please click the unmute me button when the prompt appears on your device.
Guys, thank you again for all your work you're putting into this thing. I'm going to go back to a meeting that the CAA had with the BAR in Sacramento probably about 6 months ago. And we touched on this teardown basis. And I'm going to read what I kind of defined this. And I said there may be one other definition that we need to put into our teardown, and that has to do with total loss or total loss threshold. Because when I was in Sacramento, I was told by a BAR representative that if you charge for a teardown estimate, you have to complete the estimate. You cannot just stop at the total loss threshold, or you have not completed the service that you charged for.
I think what, one, I thought I was at that presentation, but I might have missed that one. I thought I was there. But what the representative was trying to communicate was that in teardown, a teardown is not complete until you've completed the disassembly, blueprinting, or all the other terms we've used in here, and then prepared an estimate after teardown. the tear down regulations are such that that's what completes the process, is that final estimate after complete disassembly. Now, if you're disassembling the vehicle, performing the tear down, or whatever word we're using, and you get to a point where it's clear the car is a total loss, I don't think you need to continue the tear down, but you do still need to prepare an estimate that presents a total cost to repair the vehicle, damage appraisal, another word that's used, that shows that it is a total loss. I think that's what the representative should have been saying. If they communicated something different, then there was just a communication gap there.
And my question is total loss defined?
Not by us.
Not by us.
So, and I think that's what the representative, that's the word track I took, was if you're going to charge to write an estimate, then unless the estimate is complete for all repairs required, then you have charged for something you did not do.
I don't know if there's a question in there or a comment to be made. I don't know. Gotta think about that one a little bit more.
Right.
Not-
I think there may have been, again, on the part of our representative, a poor choice of words to explain the scenario there. If you charge for a charge, if you say we're going to disassemble the vehicle to prepare a complete estimate of the cost to repair, I don't think there's an expectation as to exactly how far that goes. It's whatever work is necessary to provide an accurate estimate.
I think a safe way to respond to this, not knowing the full intent of I kind of get where you're going with it, but if you're charging, let's put a dollar amount to it. If you're charging $1,000 to tear down a specific portion of a vehicle and provide a written estimate for those repairs, if you stop and cannot complete that process to the end and provide that estimate, you can't charge that $1,000 and that transaction hasn't ended because you have contracted out for a specific job that you can't complete. Doesn't mean you can't stop midstream and not complete that whole process, but if you're going to want to charge the $1,000 for that tear down and that estimate, you would have to complete that specific job. And in the instance that you're describing, you wouldn't be able to. You could stop in the middle, even a total loss. You'd have to provide something to the consumer at that point. But if you're not going through the entirety of that job, I don't see where you would be entitled to the $1,000 either. If that's what you're asking. I mean, you can't stop midstream and still collect $1,000 for a teardown estimate.
So if I hear you correctly, if we're going to charge for a teardown estimate and we have a $10,000 car and I can find $11,000 worth of damage on it, but there could actually be another $5,000 or $6,000 worth of damage, I'm going to have to itemize the entire $16,000 or $17,000 worth of damages to be able to collect my fees that I'm charging for the teardown.
You're getting nodding in agreement from some in the audience, I think. So
Okay. We'll go with that.
Yeah, I think
There's
it's-
audience agreement with how you just phrased it. So yes, that's what we're saying. Again,
And I think
and what
you
I'm
said it-
saying
you
is
said
we
it that
look at
way, too.
everything on a case-by-case basis. And so it's hard to hypothesize on certain circumstances in this environment without seeing the paperwork, the car, knowing exactly what the specific circumstances we're talking about are.
Let me try to tell you what I'm concerned about is because total loss thresholds are not defined. Your representative who's giving the presentation today just said twice that we would not be able to charge for our teardown because we did not complete our estimate.
Well, I didn't say you can't charge. I said if you were charging $1,000 for a specific job, that job is to tear down the vehicle and provide an estimate. If you're not going to complete that in its entirety, I don't believe you're at that point. You haven't completed the $1,000 job. You may have completed something else. You're going to provide an estimate that it's beyond repair. I don't know that you've fulfilled that specific job anymore at that point. The service has now changed. You're doing a partial tear down. Maybe you only took the bumper off and it's not 5, 6, 7, 10 hours worth of work anymore. And you've decided, no, this is non-repairable. I'm going to stop here. Is it fair to say that you've completed that $1,000, $3,000 service and provided an estimate for as intended, or did you do less of that service? That's what I was saying. I'm not saying you're not entitled to the services that you rendered, but you didn't complete the original service that you contracted for.
So if I write an estimate to tear a vehicle down, and I explain in my, and to, per the current guidelines, the way the draft is written, to put the vehicle back to the condition in which I started on it, and I say that that's going to take me 6 labor units to complete, and I get into this estimate and I go beyond the market value of, let's make it simple, it's a brand new car, I go beyond the window sticker on the car for it in my estimate, but I have not put every item that's damaged on that car on my estimate. What do I collect for my tear down and my inspection?
I think what Patrick is trying to say here, and I would agree with, and it also goes back to some of our earlier conversations today about our definitions of tear down or disassembly or whatever we're going to define. If you prepare an estimate that says, I'm going to disassemble this vehicle to the point necessary to provide a complete estimate for what it will cost to repair the vehicle, and you, in the example given, if you said you're going to charge $1,000 for that, if you don't disassemble the complete vehicle to provide a complete and full list of everything it would take to fix the car, regardless of whatever the teardown value is, you're committing to performing a service to provide an estimate of what it would take to repair the vehicle. The teardown shouldn't have any effect on that performance of that job. You're committed to disassembling the vehicle and providing a full and complete estimate on what it would take to repair that vehicle. So if you stop short of that because you've passed the threshold of what you believe the teardown of the value of the vehicle is, a total loss value, sorry, I said teardown, a total loss value of the vehicle, then Patrick is right. You would need to adjust what you're charging because you didn't do the full job that you said you were going to do for the value you said you were going to do.
Am I the only one in the room who sees this opening up a can of worms that we're not going to be able to close?
No, I think everybody in the room, we're getting a lot of heads nodding in agreement with what we're saying, because you commit to doing a job, and if you don't do that entire job, then you're not entitled to the entire amount you quoted to do that job. And that's whether it's a tear down, whether it's a repair or something like that. Now, I'm not saying if in the general repair industry, if you quote 5 hours to repair a certain component on a vehicle and you're able to complete that repair in 4 hours, that's part of this industry and always has been part of this industry. We're not speaking to that. But it's if you don't do the entire repair that you quoted you would do, then you're not entitled to the full compensation you quoted, the price you quoted. And
okay, so do we need to define that we are going to complete a tear down to either determine the cost to put the vehicle back to pre-accident condition or to a total loss threshold?
Yeah, I think that the proposed reg text specifically says this. You're disassembling the vehicle to prepare an estimate of the cost necessary to return the vehicle to, and we already have learned that pre-loss condition isn't a good term, but to repair the vehicle per manufacturer specifications, and total loss shouldn't have any part of that equation. You're committing to disassembling the vehicle, conducting a damage analysis, and preparing a full and complete estimate of what it would take to fix that vehicle, regardless of what the value of that vehicle is.
I'm going to argue that in several instances, a full and complete estimate is not practical. And I believe we need to have another way out of this and still be able to charge for a completed operation and not be in violation of the code.
And with your earlier call where you said that maybe we need to look at a separate regulation section to cover these kind of estimates, we'll take that into consideration as part of that, because I think you have a good point there on that earlier one, that maybe we do need separate mechanical repair and collision repair regulations. And we're going to look at that. And we'll look at that as to what a threshold is.
Okay. I appreciate it. Gentlemen, thank you for your hard work on this.
Thank you very much for the comment. We've got Gene. Did you want final comment here?
Okay, so I think, hey, Rich.
I talked you into it.
I was walking out the door. Rich, I agree with you, and I think Patrick. So what I think Rich was referring to is different than what. I don't know where you got the $1,000, right? Because we don't come up with a number before we're tearing down or we're disassembling the vehicle. And so
I'm going to defend Patrick for a second there.
But if you
have to provide a price of what you're going to charge to prepare an estimate.
Oh, okay. So let's say now we're going back to the tear down authorization, right? And that's where we may have said, Patrick, we're going to charge you $1,000 to disassemble this vehicle. What Rich Seelover is saying is that, okay, I've come up and I know that this vehicle is worth $10,000 and I've just written $11,000 worth of damage to it. Rich deserves that $1,000 because that's what he said was going to cost to disassemble the vehicle. Now, it doesn't matter that there were $6,000 or $7,000 more involved in the complete estimate to repair that vehicle to its pre-accident condition. Rich realized that at $11,000, his job was done because the car wasn't going to be able to be fixed. And so he earned that $1,000 because that's what he said it was going to cost to tear down and write an estimate on that vehicle.
Yeah, we'll have to revisit that one when we're fixing the regs.
Yeah.
I think we're going to agree to disagree on that.
Okay.
Yep. For now, but more to come. And whether we agree right now or not is irrelevant to what the final reg package will look like. The reg package will be something ideally that protects consumers and supports a successful industry, which is really what we're trying to get to.
Now I'm going.
We have a couple more commenters I heard on the WebEx. Is that correct?
Correct. So next we have Dennis Sickle. And Dennis, I'll request to unmute your microphone. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
Are we good?
Yep.
Okay, great. Let me first start out by saying that in answering Rich's question, I've been in the insurance industry for 44 years. I don't know everything, but I know a little bit about a lot. And I know most of the repairers in the state of California, in both Northern Cal and Southern Cal, probably some sitting there or on the web, I've interacted with, and I've always felt that we needed the repair facilities as much as they need us. Though we do have separate interests, that you are correct, the repair facility has a contractual obligation when they take the sign authorization from the consumer. So in answering Rich's question, is there a threshold for a total loss in California? Or is there a definition? There is a definition under the California Vehicle Code, Section 544, that defines what a total loss is and at which time the carrier is required to brand the title. Now, there is not a percentage, like in the state of Florida, it's 75%. In California, you can actually go up to 100% of the repairs of the vehicle. But as a result of an insurance claim, the insurance company has to make the decision if the vehicle is uneconomical to repair. And once they make that decision, the disclosure laws kick in. Now, with that being said, I'd like to get to the working mechanism of the teardown. From what I see up and down the state of California, we have very good repair facilities, do excellent jobs, do things the right way. Okay, just like insurance industries have good estimators in the opinion of the repair facilities, terrible ones. But more importantly, Zach, I'm going to direct this question to you. If the consumer brings the car to the repair facility and the repair facility has them sign an authorization, and in that authorization, that's an express contract, they put a flat fee of $750 teardown or a $500 teardown. Based on the way the teardown definition currently stands under the CCR 3353, it basically says, in my interpretation, correct me if I'm wrong, before you can put the wrench to the bolt, you need to be able to provide the consumer what it's going to cost to tear the vehicle down, disclose what parts you may or may not be able to put back on the vehicle, okay, so that the customer knows right off the bat, this is what I'm going to pay, and this is exactly what's going to be done. What we find in the industry is a high percentage of the repair facilities do not do that. They put a flat fee, which in my interpretation of the current regulations is a direct violation of the California Civil Code. Excuse me, the California Code of Regulations as they are written here. So Zach, can you answer the question? The consumer comes in, because many times these cars are torn down before we can even inspect them. So what is the obligation of the shop?
I'm going to take this question. This is Bill.
Okay, Bill.
Yeah, Zach's not, he's declined to answer, and he's our moderator. We don't want his answer.
Give him a shot. Can we just give him a shot?
Okay.
No, I'm sorry. So the question is on the flat fee? Is
correct? The question is, I bring my car into ABC Auto Body, I sign an authorization. There it says tear down $500. And I, as the consumer, have no idea, because I'm trusting the industry, the repair industry and the insurance industry, that they're going to pay this $500. But I don't know that for sure because the shop is in a superior position, as is the insurance company.
Right.
So what is the shop supposed to do at that time when they're communicating with the consumer, their customer? Okay. Are they required to provide an itemized estimate that represents an estimate that you would normally write, which having to list the parts that you're removing and the ones that you will not be reinstalling and write an accurate sheet?
No, they are not required to provide a itemized list of all parts that will be removed. The tear down regulations, and this is one of the things we're trying to address here, one of the challenges we're facing to get better regulations, is they're required to provide an estimate of what it'll cost to disassemble the vehicle for the purposes of evaluating the damages and providing a full and complete estimate to the repair. A flat fee, I agree with you, I think might be challenging because each vehicle and each damage is different. And so it might take different amounts for that. And the ARD's obligation to the consumer is to inform the consumer, look, we're going to disassemble where it was. We're going to disassemble and analyze any damage relevant to the collision to the right front of the vehicle and provide an estimate on what it's going to take to repair the vehicle. And that may include looking at the back side of it and a unibody car, looking at the underbody and all the other, but no, they need to provide an estimate to evaluate the damage and they should also be advising the consumer that their insurance company may or may not pay for that disassembly, and that the consumer may be obligated to pay that full amount of that full cost.
So the part that is difficult, I think, for the repair industry to understand is that these insuring agreements have specific language in there that says that we will be paying for ordinary and reasonable, okay, costs.
Right.
All right. So it would be really nice if it was possible for the Bureau of Automotive Repairs, it is a consumer-based agency, and I'm all for it. I think it's great. Okay. But I think if you're going to embrace the consumer as their agency and watch dog between the repair industry and the insurance industry, then why would it be so difficult to require that a repairer cannot put a flat fee, because it opens up Pandora's box when there now has to be a discussion or negotiation about the amount of work that was actually performed. Because many times the industry will say, well, they signed the authorization and it says here 1,000 for teardown. Yeah, I see that, but you removed a bumper, a grill, 2 headlights, and a fender. Okay, now that puts the consumer in the middle, because now you need to go and discuss with your customer. We have a mutual customer here, so we have to explain to the mutual customer that the actual work performed was not $1,000, but you signed the contract. That's an implied that's an express contract that you are legally obligated to. Well, we'll do our best, and we try our best to work with the repair industry. We could take a lot of that out if we could just take a look at both sides, okay, and see what we could do that's best for the consumer, not best for the insurance industry or the repairer. I think if we focus in that direction.
That's really, we would be in 100% agreement. We're trying to get to a place what's best for the consumer, but still allows the industries to function and do their part here as well.
Yeah, and I think that would help Rich and Tony understand, that they have a right to charge for the work that they perform. And I'm all for, and have continued over my entire career, to pay what is reasonable and ordinary for the work that was performed.
Right.
And so just hoping that maybe, as you develop this and expand on this, that we keep both sides in mind, that we got a customer, we have customers that are mutual, that we need to be working together with and not be adversarial to one another. Because I learned a long time ago, when you're pointing one finger, 3 are pointing back at you. Okay. So hopefully you'll consider that part. But as I understand it, you're telling me that as of today, if a consumer brings his vehicle into the shop, even before the insurer inspects it, because there's no relationship between the shop and the insurer, the repairer can put a flat fee of $500 to remove a fender, a grill, a bumper, 2 headlights, and that's acceptable in the consumer's interest. Is that what you're basically saying?
There's no terminology that authorizes a flat fee per se. It's if they provide the consumer with an estimate or to perform a teardown estimate for a price, whatever that price is, and they authorize that price, then that is what service needs to be completed to the point of providing an estimate that the consumer would be responsible for paying. The terminology flat price is not something that we have defined or recognize. It's a price for a service that you're saying, right?
Right, because
And we
you
don't regulate prices.
You do define in your writings, in these California Code of Regulations, you do specifically state that a teardown estimate has to be the same as and similar written as a repair estimate. So if it has to be the same, then why are we allowing flat fee to appear on a signed authorization when the consumer doesn't really know what actual work will be performed to equal that 500 or 750. I see them as high as $1,500 flat fees.
For any service, the shop can charge any price that they want. And if it's beyond a cost that anyone would reasonably even consider paying, they're not going to get any business. That's the competition of the market, and it usually dictates price. But what you're asking for, a tear down estimate is a specific job. That's why it's defined and it's expanded on, and it's explaining what is required as part of that service that you're providing to the consumer. So tear down estimate is a specific job. So when we talk about you must provide an estimate to the consumer for a specific job, parts and labor for a specific job, tear down estimate is the job. So what you're contracting to complete, and I think this goes back to some of the earlier comments too, is it's not a partial. Tear down estimate is defined what that service is, what it entails, and what's expected from the repair facility to provide to the consumer. So you're contracting for that specific job. It's expected that you complete that specific job, and whatever price they elect to charge for that service is not dictated anywhere or governed by us. It's not under our authority. We don't dictate what prices the shop charges.
Okay. I appreciate your efforts and all that you do, as well as the repair industry does. We need, like I said, when I started out, we need them as much as they need us, even though there's sometimes it could seem like that we're adversaries, and we're really not, in my opinion. But that's it. Thank you.
Thank you very much, Dennis, for the comments. Moderator, do we have another one?
Yes, this is a moderator. I have a request for comment from John Taziki. And John, I'll request to unmute your microphone. Please click the unmute me button when the prompt appears on your device.
Hello. Everybody there?
Yes.
Yes, we
Okay.
can hear you.
All right. So on the tear down thing, this whole tear down discussion, is it all because at the end result we're talking about the charges for total losses? Because the way I've always done it, and I gotta tell you, I used to run multiple shops before I owned my own shop, and we used to have the BAR come in every 6 months and review best practices. Okay, and so what we put on our estimates when we have a customer that comes in that does not have an estimate or any, even if they have an estimate from an insurance company, we're putting tear down, prepare damage assessment. Disassembly will prevent reassembly, because I have never taken a car apart that has a bent bumper reinforcement and I can't get back on that car. Right? So tearing down the car is one thing and writing the estimate's another. Do we agree with that?
Respectfully, no. I think the
Why
tear
is that?
down and then preparing the estimate after tear down are two intrinsically related things that can't be separated. You have to disassemble a vehicle and perform, and the purpose of a tear down, whether or not we continue with that word to describe the process,
right,
is to disassemble the vehicle and provide a full and complete estimate on what it would take to repair that vehicle. And just in spite of the earlier call, regardless of what the total loss threshold of that vehicle is,
right,
our expectation with the regs we're trying to craft here is that that process is to provide, and I'm going to repeat myself, a full and complete estimate on what it would take to fix that car.
Okay.
And the damage that's occurred to it.
Okay.
And that can't be separated from a tear down.
Okay. So a couple questions when you say, so is the expectation is after we do a tear down and we inspect to prepare a damage assessment or a repair plan, once we get done with that, that's it? That's all we can charge?
No, of course not, because once you start with the repair process, you may discover further damage and other costs, which
Right.
would have to be fully authorized. But the goal is to provide the goal is certainly to provide as complete an estimate as possible.
Well, I think it's a little confusing if we're going to use the terminology to tear down and inspect to prepare a complete estimate, because there's no way we can do that until that car has been through. We have vehicles that part of the repair procedure is Subaru, for example. It gets in a minor collision, you have to have the steering column inspected. That goes to our dealer, to the dealer. Okay, that's done at the end. So all the scans and the steering column can be checked, and you don't know about that till the very end, right? So when we say we're tearing down to do a complete estimate, I think that's misleading in itself. The complete estimate at the beginning.
Yeah, and we'll have to take that
Right.
into consideration when we're crafting these regs.
Right. And then back to, I just want to touch a little bit more on that tear down, and you think the estimate is one thing, basically. Taking the car apart is done by the technician. The technician, hey, take the bumper off, take the AC out, take the radiator out. Let's get the headlights out of the way. Let's pull off these fender liners so we can inspect, right?
Correct.
That's what the technician's doing. Then the estimator is writing the damage assessment or doing the blueprint, right?
Right.
I think that's also confusing too, that the tear down is separate than the estimate. Now, how we do it, and I don't know how other people do it, but I'll just give you a quick example. So let's just say I look at something, I'm like, we're going to need 4 hours tear down. So we'll put down tear down and inspect 4 hours. Okay. After I write the estimate, I get, I review all the repairs. Okay, hey, we tore it down. We got 5,000 worth of damage. Yep, go ahead and fix it. We credit back. We don't charge. We put it on there just in case the car totals. We don't charge for tear down. We charge it, but then we credit it right back.
Which is common and
right. You credit it back after you get done with the estimate.
Yeah.
Here you go.
Most shops do that.
Yeah, exactly. So, man, that was a lot of conversation about people getting paid for, it's really comes down to the only time that runs into a problem is when the car's a total.
Right.
Okay.
I would agree. That's when it comes into question. But again, I think my point was, I know my point was that the purpose for the tear down in the Bureau's eyes is the goal is to get as close to as reasonably possible to identifying all the damage and preparing an estimate so that the consumer and ultimately the insurance company, but mostly the consumer knows before proceeding with trying to fix this vehicle,
right?
They have a good ballpark figure on what it's truly going to cost,
right?
Either their insurer or themselves.
Well, it's really nice to see that the BAR has involved the insurance company in this, and maybe the insurance company and the DOI will involve us in some of their conversation so we can all get on the same page. Because
we again, as the chief said, it's a public hearing. Anybody can show up at the hearing. And
no, I understand that.
Yeah,
so
we involve all stakeholders because I think that's how we can all get to the best place possible.
Well, my point was, it was nice to see you guys involve them. It'd be nice if they involved us, is what my point was. Because there's a lot of things that just doesn't jive with both parties. Like the last insurance gentleman said, we do have a mutual customer, but it always seems like the body shop is the one that really cares about the customer. So, all right. Well, I look forward to seeing the next things, the next
all right.
Write out of what's coming up.
Okay. Thank you very much.
All right.
Any more?
This is the moderator. I don't see any other raised hands or requests for comment in the Q&A. Would you like me to close that Q&A panel?
Yes, please. Thank you very much. Jeff, did you have another comment? I saw you. You're welcome him, please.
I want to hear Zach's opinion on tear downs.
Jeff, your comment, Zach is going to respond to.
What's that?
Zach is going to respond to your comments no matter what it is.
That's all right. I think it seems like we're getting on a path here that is maybe not so adherent to reality. Customers don't come into shops anymore kicking tires. I'll go here, get an estimate. I'll go there, get an estimate. The insurance company wants me to get 3. When they come to our shop, they know they want it fixed there. They're coming there to get their car fixed, not to get it estimated. And again, the key word here is estimate. You do a disassembly, and we go through what's called DFR, Discovery for Repair. And we write up the estimate. Keyword there is the estimate. It's an estimate. You guys aren't asking for a final bill, right? Okay, so we write the estimate. We do the repairs. Now let's just say, I'll just give a quick, easy example. We've got a post scan that's being done. And in that post scan, they find up now that we need a new ECU. That's $1,500. We need a new clock spring for the airbag or something like that. That's another $500. And you could be $2,000 higher. So I don't think a shop is going to get held to their estimate being, oh, if it's not that exact $1,527.33, you're in violation. I don't think that's going to happen. Second of all, as far as doing teardowns, when we do a teardown, we charge a flat fee where we're at. I charge a flat fee for doing a teardown, and that includes a pre-scan. All right, you have to do a pre-scan on a car. Well, if we're fixing that car, the amount of money that we charge for a flat fee of a pre-scan, I don't care if it's $8,000, it's getting incorporated into the repair. It doesn't, the insurance company doesn't pay anything for that. And like the gentleman said a little bit ago, it's only going to happen in the case of a total loss. They don't want to pay the teardown price. Well, we could charge by item, but you know, when you've got in California a average severity of $4,700 per ticket, I believe it is, they're going to pay a lot more than the price we charge for a teardown. I can assure you that. We tell our consumers when they come in, we're going to charge for a disassembly. Teardown is what we use out in the shop. Disassembly is what we use in the office. Well, customers are more comfortable with that term. We tell them that we're going to do a disassembly for the repair. It costs this much money to have it done, and it includes a pre-scan, so we can scan all their ADAS systems and things that come up. And we also let them know that it's very unlikely that the car is going to be able to be reassembled. And we vet them, and I feel that it's our obligation in the industry to communicate with the customer, to let them know the reality of this, that you have a choice in California to have your car fixed anywhere you want. And when you choose a shop, you kind of need to know that's where you want to get it fixed. And hopefully you've chosen a shop that's reputable, that's doing a good job. And believe me, I'm not in the teardown business, and I'm not in the storage business. I'm in the fix the car business.
Yeah.
And that's what I want to do. I do believe that we have to have some restrictions on storage, so we don't have 21 cars waiting for insurance adjusters to give me an approval sitting out my back lot, and I can't take any more in. But anyway, I'll make this short. And I think that the tear down flat fee is the right thing to do. And Jack, is that good now? You're not addressing?
Jeff, you must have had a really good round on the golf course today.
I didn't play.
Oh, you didn't
I
play?
just went out and hit balls and
Oh,
practice.
okay. Well, geez. Yeah. I did. That's an excellent point about the itemized. There is no such thing as an itemized teardown estimate. It's itemized repair estimate. We don't have any requirements on that. So, yeah.
Thank you.
Brought that up. Yes. Come on forward, Oscar. Speaking of estimates, we were really off on our estimate for how long this workshop would take.
It's a world record for longest comment. See, longer presentation.
Hoping
ahead,
to get,
Oscar.
I have two of my managers that this morning says, "Oh, we'll just give you a ride. No big deal." Now they're sitting in the back going, "Man, we should have made you drive yourself."
Go ahead, Oscar.
Hoping to get some clarification from the BAR since lately seems like it's, at least in our facility, has been confusing depending on who we talk to from the BAR. So hopefully you can give me clarification on when body shops can charge storage. So I'll give you two different examples. One example that happens every week in our body shop is when a vehicle comes in and we look at it. Just by looking at it, we feel that it's going to be financially economical to deem the vehicle a total loss. At that point, we let the consumer know, the customer will let the insurance company know. Maybe we'll send some photos to the insurance company. And if at that point they'll like to deem the vehicle total loss, they might be able to do it right there and then and minimize the cost of storage and get that vehicle out of our facility as soon as possible so that we can, as a body shop, bring another vehicle in. So that's one scenario. And as far as I know, we as body shops were able to charge reasonable storage in that scenario. Would that be correct? Bill?
Oscar, you're not going to like my response. This reg package doesn't address storage, and storage is going to be another reg package. And so from what from your timeline you just have here under current law and regulation, this seems correct and is appropriate. Whether or not that changes when we start looking at storage regs is up for discussion. So that's the best answer I can give on storage right now.
Just so that we can go back maybe whenever that time is appropriate. Let me express to you the second scenario that we often see in body shops, and it's
Sure.
when the vehicle comes in and the vehicle might seem financially economical to repair it.
Right.
Maybe it's the front end damage. We disassemble the vehicle, and after we do the damage analysis, we find ourselves that based on the threshold of the estimating system, the vehicle might end up being a total loss. Maybe it's at, let's say, 80%. Right now, since we have Copart involved in some of those vehicles, especially hybrids, the batteries are so expensive, so they have a high total loss value. And maybe in our eyes, it might be repairable, but it's questionable. It might be borderline. At that point, we contact the customer. We'll let the customer know, hey, would you like us to share the estimate with you and the insurance company in the same email? Most of the time, that's the way it goes. Goes to the insurance company. The insurance company at that point might say, okay, hold on, don't do any repairs, stop. We're going to A, send someone out to inspect the vehicle, or B, we're going to take our time to write up our estimate. Many times the vehicle ends up being a total loss. And what the question is on that scenario is, since the moment that we as body shop, we fulfill the contract with the customer, and we're being stopped from continuing any repairs, are we, the body shop, entitled to charge storage since the moment that we fulfill the contract with the insurance company, or are we only entitled to collect storage from the moment the insurance company deems the vehicle a total loss? And here's what we're seeing. Many times, from the moment that we fulfill the contract with the customer to the moment that the insurance company might deem the vehicle a total loss, might take 2 weeks, 3 weeks, and the vehicle is in our facility taking valuable space. And we would like to get the vehicle obviously removed from our facility so that we can bring another vehicle that we can repair.
That's exactly what we're trying to address with the changes to 3352, is to put a time limit on that process to where you disassemble the vehicle, perform a tear down, if you will, provide an estimate to the consumer and to their insurance company. And what we're seeking to do with this reg, maybe it's 3353, that when you present the estimate and obtain the authorization to perform the tear down disassembly, you state in there that upon completion of the tear down, when your facility or any facility provides the estimate to the consumer and their insurer will have X number of days Currently in the proposed draft, it's 6 days. We've heard all the comments and we're going to discuss that number of days to make a decision, to either remove the vehicle from our facility or make a decision to authorize the repairs or declare it a total loss. At that point, whatever that number of days is, that's when you would be able to charge storage. That's what we're envisioning with this reg package. Not to have repair facilities waiting 3-4 weeks while an insurer drags their feet to authorize continuing with those repairs, to put a time limit on it, to give the ARDs a reasonable ability and to charge storage. So
I think
hopefully
that's
that
going
answers
to
your
help
question.
the industry on
That's
both
what the goal
sides.
here is. We may not have communicated that, but that's really what we're trying to accomplish with this portion of the reg package, is to create a mechanism to put a time limit on authorizing further action with the vehicle, whether it's removable or repair.
And as of right now, there is no time limit, correct?
No, there isn't specific regulations or statutes that discuss that just yet.
Well, I think that's going to help the industry and it's going to minimize, at least in that aspect, the friction between third-party payees and customers and repair facilities. So thank you.
You're welcome.
Thank you again. Everyone exhausted? We got one more? No? Is that it?
This is the moderator. We have one more request for comment on WebEx, if that's all right.
Sure.
All right. Rich, I'll request to unmute your microphone. Please
Unless
click
it's
the-
Rich.
Please click the unmute me button when the prompt appears on your device.
All right, guys, sorry, but recapping what Oscar just went through on the putting the time limit on the shop before we can charge storage actually extends the amount of time the insurance industry has to respond. Because if we can charge storage the day we determine it's a total loss, that's going to take money out of the insurance industry's pocket and promote them to respond quicker. I think we're going at this backwards. If we put a 6-day clause on the insurance industry, that would be fine. But I think it's backwards putting a 6-day clause on the shops.
Yeah, I think we need to put some better clarification in there, because I think total loss and repairable vehicles are different, and we have to figure out how to address those in regulations. Because we were looking at repairable vehicles.
Right.
And I agree with what you're saying, that total loss should be different.
Okay. Guys, thanks for your time today. Sorry to drag this out.
No worries. Thank you for all the excellent comments throughout the workshop. Is that the last one?
This is a moderator. I don't see any other hands on WebEx.
All right. Yeah, Bill has left. Elvis has left the building. All right, we're going to close this up. Thank you, everyone, for participating today, for your attendance today. I am so sorry that we underestimated the amount of time to cover this material. We will not do that in the future. We will allow enough time for you to calendar this appropriately. But I do appreciate everyone sticking around to the very end. Stay tuned. We will go back to the drawing board and we'll take a look at the regulations. I think not to drag this out much longer, but just this is representative of the importance of this process, workshopping these regulations and getting feedback from the stakeholders. And in this case, there are the auto repair industry stakeholders, there's consumer stakeholders who aren't necessarily at the table, other than for the Bureau of Automotive Repair, who stands in the shoes of the consumers. But we also have the insurance industry as a stakeholder here too. And we have to recognize that. I know some aren't necessarily comfortable with all of that, but it is important to us to recognize it as a regulatory entity and try to bring all of these parties together and try to reach a common ground and a solution to some of these very vexing issues or problems before us. So thank you very much for being here today. We'll make sure that we get notification out to all of you on the next workshop. I'm sure we won't go into a final draft of the regulations. We'll want to get feedback once again on the next draft or next iteration of this package. We'll let you all know when that next workshop opportunity will be. Thank you very much again. Have a good rest of your evening. Thank you. Bye.